All right, good morning, counsel.
Good morning, Your Honors. Jamie Vandersam for the defendant, appellant Katia Dotson. The main issue in this case is whether a defendant receives the benefit of a penalty-reducing amendment that becomes effective between the time of her offending conduct and sentencing. Before I address that, I'd just like to address a couple of preliminary issues. One, mootness. The Commonwealth touched on this in its brief. I did not. I agree with the Commonwealth. This is certainly not moot. The probation sentence in this case is over, but it's not moot because the probation sentence can be held and will be held against defendants. And those of us who spend time in district court know a judge will look at the number of probations you have and say, well, you've had it before, and therefore we're not going to give it to you now. So I don't think this is any different from a case where you're talking about time in prison and whether that might be moot, even though that's finished.
I'm trying to understand one of your arguments about probation. If this were not a first offender but a second offender, disorderly conduct, where the statute provides for a period of incarceration and, I think it's and or a fine?
Yes, Your Honor.
If the judge imposed incarceration and a fine and then suspended the sentence, placed the defendant on probation, would the defendant have to pay the fine?
Well, your question, Your Honor, is could the fine be the payment of the fine be held out as a penalty upon violation of probation?
Well, that's one way to answer the question.
Yeah. That's a good question, Your Honor. I don't believe so. I don't. I think the. I simply don't think that is consistent with. I guess I don't see that as consistent with fining. I think there's something inherently odd about holding over a fine over someone's head.
Person can't afford to pay it.
Yeah, that was my question. What happens if, forget this, just if you got a new statute, you get convicted, and you have a fine. The first offense, a fine is imposed, and you can't pay it. Then what happens?
Ultimately, you may actually be forced to pay off that in jail. You may. That does happen.
So you're saying a judge cannot put a person on probation where only a fine is involved?
Yes.
Even though the judge recognizes the person doesn't have the ability to pay the fine and says, look, if you do these certain things, you will not have to pay the fine.
Like community service?
Yes, Your Honor. Yes, I am saying that because I think you have to go back. I think what you're saying is that person is then on probation. I think you have to, again, look back. I think this all boils down to the definition of probation. If we go back to the statute 276-87, which the Commonwealth has referred to here, it certainly does say probation may be imposed in any case upon conviction. But probation, by definition, I think we have to stick with the definitions. If you look at actually Chapter 4, Section 6, Paragraph 3, we have to go with the traditional definitions of these terms, such as probation, in construing that statute. Probation is something that is an alternative to incarceration. This Court has always either said or implied as much. Most recently in Commonwealth v. Goodwin, the 2010 case, which the Commonwealth refers to in its brief, the Court is very clear about this. And Commonwealth v. Durling, Black's Law Dictionary, you can go anywhere you look for a definition of probation.
But isn't that because the cases in which the issue comes up is almost universally involving one of incarceration?
Well, that is certainly true, Your Honor. I think you won't find any of these cases like where someone has actually been in I haven't had personal experience. I don't think you'll find any case law where this is the case, where someone has had probation imposed where incarceration was impossible.
With regard to corporations,
they're fined all the time, and the court imposes a probationary period to say you should be complying with this environmental mandate or whatever the source of it is. If you comply over a period of 2 years, if you put in new management, if you have a compliance officer, then you need not pay the fine and burden your shareholders. Why is that not a perfectly sensible thing to do when you have an individual who may have a substantial fine and can work it off by improving their conduct?
Well, I'm not sure whether it wouldn't be, the Commonwealth mentions this. They make the point that it's a perfectly sensible thing to do. I'm not sure that it is, I think this court is bound by the actual meaning of the terms used in statutes. And as to, I think that there's a reference there in your question, Your Honor, to a Springfield Railway case, I think, which came out last year, where where a corporation was put on probation, and that was okay by the court. I think incarceration actually is a possibility under that environmental statute. But in any case, obviously you can't put the corporation in jail. I would say that's kind of an outlying exceptional case where by the nature of the defendant, they can't be put in jail. And therefore, in that case, practically speaking, incarceration is not an alternative. And therefore, in that case, the meaning of probation is slightly different.
Well, shouldn't your argument be that probation is a significant infringement on one's personal liberty? And if a statute contemplates the payment of a fine, that really is not an infringement on one's liberty. Probation may include the standard conditions of probation, regular reporting.
Yes.
Isn't that the essence of the difference?
I think so, Your Honor. I think it kind of makes a mockery of probation, quite frankly. If the legislature has put a $150 price on an act, on an offense, and that's what they've done here. That's what they did effective July 1st of 2009 to this first offense disorderly. If they put that price on it, I think so. Therefore, that is going to be the only thing keeping somebody actually complying with the terms of probation. Let's say here, for example, you've got someone on probation for 2 years, and you've got to follow all these conditions as the defendant did. If the only threat is the $150 fine, I must say I think that kind of makes a mockery of the probationary term, because it is a very minor disincentive.
But more than that, if you are on probation, you have all these conditions, it may be the case that if you violate them, all the court can do is impose the maximum fine, but then you have on your record that you violated a prior term of probation. Mm-hmm. There are consequences to a sentence of probation that go beyond the payment of money.
Yes, Your Honor. Yes.
But I thought you said, though, at the beginning, let's take, you've got a homeless person who is convicted of this, and the 2009 version of the statute, there's no question that it applies.
Yes.
Homeless person says, I do not have $150. I just don't have it. I'm not going to get it. What is the judge supposed to do? Say, okay, there's no penalty here?
Well, the judge can assess a $150 fine, and then the defendant can actually be made, if they cannot pay it. This often works this way in district court, in my experience. If the defendant cannot pay it, almost all of the judges are very reasonable in accommodating people, for example, by allowing them to do community service.
That's right. But so somebody's got to supervise the community service, right? Exactly so. I'm just wondering, how do you implement that?
How do you implement that?
Don't you do it through probation?
Yes, the probation department would be in charge of that, yes.
So that's not imposing probation.
Yeah,
you may continue the case for 180 days to enable the person to work off the penalty, but imposing probation, I think, is quite different.
Yeah, that is not that's not probation. It is simply, okay, here's an option as an alternative to paying off this fine. And again, another option ultimately is, I don't know whether it is still $30 per day in jail, but that too is something that is ultimately seldom in my experience, but may be done. But again, that's.
I see. Okay, so these are just, in your view, it's what Justice Court says. It's not probation. It's means of getting to the $150.
Yes, that's not regarded as probation by the court. That is not a probationer. Technically speaking, that is not a probationer. That person hasn't been put on probation. They've been fined, and there will be an arrangement made. Okay, come back to court on this date and tell us how it is, whether you've paid that or not. And I'll look at the probation officer and ask him.
Well, wait a minute. It seems to to me that one of the problems with saying what you just said is that fines are remitted to the general treasury. Community service is not. The judge is diverting something along the way there, and I'm wondering by what authority, if not by probation.
I'm not sure by what authority, Your Honor.
Well, presumably, if he's sent to jail to serve out his penalty, the Treasury's not getting any money from that either, at $30 a day.
That's correct. That's correct.
It might be an alternative to actually being incarcerated as a pauper.
Yes.
Anyway, let me ask you this question. Let's assume for a second that when the statute was amended to create this two-tier sentencing structure to disorderly person, when the statute was amended, the Commonwealth then went back and essentially got an amended complaint charging your client as a subsequent offender. Mm-hmm. Would that violate any principles? Could they have done that here?
I don't see why not.
All right, so it's no ex post facto because there was no subsequent offender offense previously? Although the penalty, I understand, is the same, but that's not going to be a problem?
I don't think so because the penalty remains the same, Your Honor. Okay. I don't think so. If I could, though, just if I could address this issue, which I see as the main issue in the case, this has been the law consistently that the defendant in the Commonwealth, that the defendant is presumed under a penalty reducing statutory amendment to get the benefit of that change. The Commonwealth raises this Nasser versus Commonwealth case. About 50 years ago, this case came down, and I think that is an important case to focus on when it comes to the law, the state of the law in the Commonwealth, according to the cases. Nasser v. Commonwealth was a case where a legislature said, okay, what used to be criminal is now delinquent for people of a certain age, and it was certainly an ameliorative amendment, but the court said, look, this is not merely procedural or does not merely affect punishment. Contrast Commonwealth v. Wyman, one of those 1850 cases. And therefore, we're going to say that this is a repeal such that this falls under Chapter 4, Section 6, Paragraph 2. The only difference, this is merely a matter of penalty reduction for somebody who is charged with the first offense of disorderly conduct. The only thing different after this statute, for a person who is simply charged with something called disorderly personhood or that kind of disorderly conduct, the only thing that changes, the only thing that has changed post July 1st, 2009, is that person's maximum sentence is now a $150 fine. I think it's a real stretch. I don't even quite follow. The Commonwealth is claiming that there's some substantive change that analogizes this to the change in Nasser because when it comes to the subsequent offender post July 1st, 2009, there's going to be a different process in the way that subsequent offender is actually charged.
But you have to allege subsequent offense. That's a state constitutional matter.
I'm sorry?
You have to allege that the crime was committed as a subsequent offender.
Absolutely, and that's a change. But it doesn't change at all the fact that the person who is, first of all, it's very unclear under Nasser what line they're trying to draw, and I think there's a problem with Nasser. I would suggest the court should actually revisit Nasser because it's unclear what is substantive enough.
Could I ask you this question? It's a technical one, but you seem to be thinking, don't go here. I read Nasser, and it talks about repeal of the first statute. I looked at chapter, whatever it is.
The Acts of 209?
Yes, 209, and it talks about amending. So does that make a difference?
Yeah,
or is that just, those are just words?
There is some language, Your Honor, in Nasser that says, both partial and whole repeals will fall under this Chapter 4, Section 6.
But I didn't go back and look at what the legislature did, but I'm assuming that they said X statute is hereby repealed, and here's the new one, which is not what the legislature did in 2009.
I'm not sure what they did. I'm not sure about that, Your Honor.
Okay, so you're not relying on the fact that this is an amendment and not a
I'm not
repeal.
relying on that word alone because the cases, if you do look at them fairly, I think you can say, well, at least under it's arguably an amendment. If you look at some of these pre-1869 cases, you can look at this and, an amendment, a repeal, they're kind of treating, when there's an increase or a decrease in punishment, the courts are generally looking at those as amendments, as repeals. I'm sorry, I'm out of time. Thank you very much.
Thank you.
Morning, Your Honors. May it please the Court. Zach Hillman on behalf of the Commonwealth. We're asking this Court to affirm the defendant's probation sentence in this case. I think it makes sense to focus first on the issue that I briefed second, and that is whether the judge has the authority under the probation statute to impose probation where the sentence provided for in the statute that's been violated is merely a fine. I think that it makes sense to address this issue because I could make the question of which version of the statute applies moot. Now, as far as Section 87 goes, that provides the judge with authority to impose probation, and that's in addition to the statute, the sentences that are laid out in the statute that has been violated. Section 87 provides a broad general grant of of sentencing authority that has to be read in harmony with the sentence that has been violated.
But so what would you say in this case? Let's assume that the judge can put Ms. Dotson on probation and she violates every single term of the probationary that he has said or she has said. Assuming the 2009 statute is in effect, what then?
Well, I think the judge has a few options available to him. He could certainly have her pay the $150 fine. Alternatively, he could say these probation conditions are not working for this probationer. I'm going to impose an extended probation period or impose new and different probation conditions so that she can
Judge cannot sentence, cannot put her into jail, though, correct, for violating probation?
Under the 2009, I don't believe so. I think what is kind of
the judge could have her on probation for the rest of her life if she just keeps violating?
I mean, I think that there may be a question of how far the discretion goes as far as how long he can put someone on probation. But I think the point is what is hanging over the probationer's head
Well,
is...
think about this for a moment, though. I'm putting you on probation for 2 years. And, oh, by the way, what's the monthly probation fee that you're going to have to pay?
$60?
$60 a month? It's a $150 fine offense. You're going to put you on probation. You have all these reporting requirements. You pay $60 a month. How's that authorized by the $150 fine as the maximum penalty for the offense?
I think we have to look at it like this. The legislature said that the defendant can be sentenced up to a $150 fine or probation. The legislature knows...
Probation, you mean somehow referring to 87?
Absolutely, Your Honor.
Although it didn't say that in the statute.
Absolutely, Your Honor. And I think the reason it doesn't say that in the statute is this. Section 87 authorizes a judge to impose probation in all criminal convictions with certain exceptions. Disorderly conduct is not among those exceptions. The way that the statutes have to be read together are...
Well, the exceptions are for really serious crimes.
Exactly, Your Honor.
So
exactly.
It didn't. I don't know. What about a criminal motor vehicle violation?
I can't.
I suppose if there's a jail sentence that goes with it, that might be that clearly could be suspended in a period of probation. Go ahead. I'm sorry. I didn't.
Well, I guess my point is, Your Honor, the legislature intended that these two statutes be read in harmony. It would be, I would suggest, not expedient for the legislature to have gone through every single criminal statute that includes some sort of sentence and put in or probation. The way they made this the most expedient way as possible is to provide this general power in Section 87 and then have the certain limited exceptions for which a judge cannot put a person on probation.
Let me ask you a question. If imprisonment is not a possibility, would somebody charged as a first offender have the right to appointed counsel?
I don't think so. I don't think so, Your Honor.
Even though this whole question of probation and whatever that means might be facing the person.
I don't think so. I don't want to say conclusively no, but my understanding is no, and that's because, again, the legislature knows what costs are attendant to probation, what programs a judge may put a probationer on, and they authorized this grant of sentencing authority under Section 87 to the sentencing judge. Interestingly enough...
There's always the question of violation of probation and the consequences.
Certainly.
And unless we were to say in this situation only, or in situations like this, that probation could never have, a probation violation could never result in imprisonment.
I'm sorry, Your Honor, I don't know,
I mean, is
quite
that,
follow your question.
is that the consequence of probation in this circumstance where, somebody does not have a right to counsel, but probation gets imposed, but the violation of probation could ordinarily result in incarceration, but we'd have to say it couldn't here.
That's correct. And
Then where's the teeth to probation?
the teeth in this case is one, the fine, or two, as was alluded to earlier, the fact that if a person has a violation of probation on their Board of Probation record, it may change what happens in the next instance with bail, with how the Commonwealth is going to proceed in the case, with sentencing decisions after a further conviction, if there is one. I think the question of whether probation applies in a case where or the question of whether probation is just to allow someone to remain at liberty is contrary to what probation, the rationale underlying probation in the Commonwealth.
But, I mean, just to take that, when you apply, I haven't done any legislative history of Section 87, but I would think that its purpose was to say in any case you can apply probation as, silently in lieu of incarceration. But in this case, if the legislature has said, we think a first offense is worth a fine, doesn't it sort of violate that legislative purpose if you can impose, a judge can impose quite, onerous probation for however long he or she wishes to do? It just seems to me it goes against the idea that, this is really something that the legislature is not, in the large scheme of things, taking terribly seriously.
Well, I disagree, Your Honor. I think that the question of whether probation is more onerous, I think, is not really the question. The question is, what is the sentencing option available to the judge here as set out by the legislature? And the options are the $150 fine or a term of probation. Interestingly enough, the probation statute has been amended and effective on February 19th of this year. It adds 2 new crimes for which probation cannot be instituted. Disorderly conduct is not among those.
What are the crimes?
They are the sex trade and
Very serious crimes for reasons having nothing to do with whether we think something is so trivial probation shouldn't be given. It's rather we think something's so serious that alternatives to incarceration should not be considered. Isn't that just the opposite side?
Absolutely not, Your Honor. And I think this case is a great case of what probation can do and what probation is for. The judge here was faced with a defendant who, as he put it, had some serious anger issues. He thought that a $150 fine may not address those issues. Probation, or the legislature has recognized that probation has been instituted in the Commonwealth of Massachusetts for rehabilitative purposes, and this judge said that this defendant needs a chance at rehabilitation here. How do I best do that? I impose probation.
Let me ask you this. I asked your brother, do you agree with your brother that you simply could have amended the complaint or gotten a new complaint charging her with being a subsequent offender, because she was, and then the judge would have the full range of sentencing options, including incarceration and probation and fine? Why isn't that the answer here?
I think in hindsight we could have done that. But given our reading of the probation statute, it wasn't necessary, because the judge always has the authority to impose a probation in a case like this, regardless of whether there's imprisonment hanging over someone's head, or if it's the $150 fine, or the consequences that come with violating probation.
Should we interpret Section 87 where there's only a fine as an alternative to say you may impose probation, but only with the approval of the defendant?
No, I don't think that the legislative grant to the judge is so narrowly construed. I think the plain words of the statute tell the judge that he has the authority to impose probation for conviction of any crime.
So that means then that if it's imposed against the defendant's will, the defendant can ignore it and simply be violated and say, okay, fine me. That's all you can do anyway.
Well, no. The judge could impose the fine, or he could extend the terms of probation, put her on some new programs. But certainly if a defendant says, I don't care that my board of probation record is going to have a violation of probation notation in it, he or she is free to do that, certainly.
And you agree that ultimately the only sanction the court has, apart from declaring a violation of probation, ultimately if the person says, I'm going to do nothing, I'm not going to comply, is to impose a fine.
That or impose, again, continue out the terms of probation or impose new conditions, perhaps put her on a different, perhaps mandate that she take or participate in a different rehabilitative program under Section 87A.
Okay, but ultimately the person can just say, I'm not going to do it.
That's correct, Your Honor.
And then
Certainly.
ultimately it comes down to a fine. There's no possibility of incarceration.
I don't believe so.
Okay, which means that person could not be held in contempt for failing to comply with probation. You'd agree that that would not be an appropriate sanction where there's only a fine.
I don't know the answer to that question, Your Honor.
What if the individual hasn't paid their monthly probation fees? There's no collection mechanism? Surely there's a penalty attached to pay probation fees?
I think that would be a violation of a term of probation, and then that probationer would be subject to a violation of probation hearing in that case. Now, as far as the issue of which version of the statute.
I'm a bit confused about that.
Sure.
Because you said that you could have brought a later complaint alleging subsequent offender.
Sure.
But that seems to concede that the later statute would apply.
Well, I think the very fact that we would have to go and null pros the pre-2009 complaint and take out a new complaint supports our argument that the very fact that we would have to take out a new complaint makes this a substantive change to the way that the Commonwealth is going to prosecute these cases, just as was the case in the Nassar case. It's going to change how we charge someone. It's going to change our decision going forward. If a person is convicted, we're going to need perhaps different witnesses than we would have at the underlying trial. It's a whole new process that's going to force us to prosecute these cases differently than we would, for example, in this case.
And is it your view that you had that alternative here?
I think we would have had the alternative here, just as the defendant would have had the alternative in Nassar.
I don't get it.
Just because we would have been able to null pros the complaint, go back, take out a new complaint, and allege that this person was a subsequent offender, doesn't mean that this isn't a substantive change. The very fact that we would have to do that means this was a substantive change.
But the disorderly conduct still occurred on July 13th of 2008. I don't see that your null prosing and doing a new complaint would have any consequences. Is it your view that this crime applies to crimes that occurred on July 13th, 2008? That the new statute depends upon the date of the complaint?
No, I'm not alleging that at all. My point is, were we going to prosecute under the new amended version of the statute? We would not have been able, if we wanted to count the defendant's prior disorderly conduct convictions in our charging decision, we would have had to have gone back and taken on a new complaint.
Well, I understand that, but I guess my question is, would you be lawfully permitted to have done so?
I think we would have been lawfully permitted to have done so. But the fact that we would have had to have done it that way means that the whole process of charging a person as with disorderly conduct has changed.
Okay, and if you had done so, would the person be convicted of being a subsequent offender or just of being an offender?
Well, it would have been a bifurcated trial. Obviously, it would have been a trial on the underlying a crime, and then
What would the judgment say? Would the judgment say that the person is a subsequent offender, or simply that it's an offender under the old statute, and they have these prior convictions which may affect sentencing?
I think it would be if we were going to prosecute the person under the new statute, it would be a person who's been convicted of disorderly conduct, a second or subsequent offense. Just as a second or subsequent offense.
But you concede that if there was a greater penalty under the new statute, you couldn't have done that.
We could not have done that if there was a greater penalty under X.
So it's only because of the fortuity that it happens to be the same.
That's correct, Your Honor. I agree with you. Given ex post facto concerns, we would not have been able to proceed had the penalty been higher.
Counsel, your time is up.
Thank you, Your Honors.